case briefs, and so much more. LSData's got what you're looking for.
In the 1980 case Berlitz Schools of Languages of America, Inc. v. Everest House, the United States Court of Appeals for the Second Circuit focused on the issue of collateral estoppel, which prevents parties from raising the same issue in future cases if a court has already made a decision on it. The lawsuit was initiated by the Berlitz Schools of Languages of America against Everest House and its president, Louis W. Gillinson, for trademark infringement and unfair competition. The issue was the publication of a series of foreign language instructional books called Step by Step, authored by Charles Berlitz, which the plaintiffs claimed violated their trademark. Although Berlitz attempted to sue Everest House and Charles Berlitz for trademark infringement and violation of a prior declaratory judgment, the judge denied their request for injunctive relief, stating that the doctrines of collateral estoppel and res judicata may prevent the current action. The district court granted the defendants' motion for summary judgment, and Berlitz appealed the decision, arguing that their complaint raised different factual issues than those previously addressed in state court litigations. However, the court determined that the earlier state court proceedings had addressed similar claims, barring the current action. The court found that the slight modifications in presentation and disclaimer were not significant enough to warrant another proceeding, and it affirmed the defendants' summary judgment.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.